Great news, friends. After 21 years of living in the US without a status, client will finally adjust status before USCIS. My name is Bijoux, Ngwanda, I'm an immigration lawyer here based in DC. I do work with individuals across the country and around the world because we're dealing with complex US immigration cases. If you're new to my channel, please go ahead and subscribe if you're not new. Welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss anything. If you enjoy the content, come on, go ahead and share, like, and don't forget to comment below. Also, if you want, you can join us on our private Facebook group where we answer questions live at least twice, a month. You really have to be patient when you join us on our private Facebook group. Link in the description box below. Let's get right into it. We have been able to terminate removal proceedings. Remember that termination of removal proceedings is not something that they just give to you easily because you have an I-130 approved. You still have to be able to show good cause or good reasons as to why the judge has to terminate removal proceedings. And if in your case there are a lot of allegations, right? Especially if you have allegations as far as fraud, as far as misrepresentation, most likely the judge will not terminate removal proceedings. They will want you to adjust status in court so that they can assess all those facts, right? And that's really difficult if you have to go and adjust in court because the standard is pretty much higher. Okay? But this is what happened with this case. I'm going to give you a timeline, okay? Client entered the United States 2001, B1, B2 visa. 10 years later, 2011, I believe around 2012 or earlier, she applied for asylum. Too late. Even though the asylum claim itself is very good, but it was too late. She did not meet the deadline, 1 year whole deadline exception, because she didn't really have an exception as to why she was applying late. Remember that you can apply for asylum late provided that you meet the exceptions, the 1 year deadline rule exceptions, which are either change in circumstances in your country of origin, you weren't aware of the fact until that time, or the facts really became relevant that time, and then, or it can be extraordinary circumstances, right, beyond your own control. That's why you're applying late. And those exceptions are really hard to actually demonstrate. You have to have a lot of evidence for it. So this client, she just didn't meet the exception, right? The case was referred to immigration court. And as a defense, former attorney applied for cancellation of removal, okay? But unfortunately for her, she never had the chance to defend the cancellation of removal application with former lawyer because, first of all, the court delayed, delay, backlog, well, she couldn't. Not to mention, on top of it, former attorney was still continuing the cases, just pushing it without any valid explanation. Client had to actually fire former attorney and then hire us when she actually met us on YouTube, okay, in 2021. So by the time the client came to us, the child was already almost 2021. Meaning what? Meaning that cancellation of removal as a defense was not going to work anymore because the child was already independent, working. There's no reason to actually prove extreme hardship. How are you going to prove it? Because the child is independent, the child is working. Well, pretty much that's just like, it's not going to work. So I told her, you know what are we going to do right now? We are going to wait for your child to turn 21 and we're going to apply for a petition of a relative, right? I-130 petition. That's what we did. We applied for I-130 on July 19, 2021. We got an approval on April 27, 2022. Almost 10 months, I believe, or 8 months. Almost like 10 months later, we got an approval. But guess what? You cannot adjust status with USCIS when you are still in removal proceedings, or you have an order of removal, or like what they call withholding of removal, unless an exception applies, right? But there was no exception. You're in removal, case is pending, you have to adjust in court. So at the time we got an approval, that's when this Biden memo came about, right? This prosecutorial discretion, the doily memo. And we tried that. Trust me, we tried it twice. Deny the first time, we tried again, deny. We said we're not gonna wait. We are just gonna move to terminate removal proceedings. And remember, this is Maryland. The judge has the power to terminate removal proceeding, because we are actually in the, I believe, Fourth Circuit, if I'm not mistaken. But anyway, the judge has the power, because in other courts, the judge does not have that power to terminate removal proceeding. It really has to, basically, you have to go with DHS and stuff like that. It's just depending on what circuit, right? Some circuits just don't allow that. Some circuits don't even allow administrative closure, like Ohio. I believe they're in Fifth Circuit. They don't allow it. So in Maryland, a little bit friendly, but still we had to fight for it. Remember, PD was denied twice, right? So then we went ahead and applied for that. We filed a motion to terminate removal proceedings based on the fact that we have an I-130 petition, and not to mention that sponsorship requirement was met with two sponsors. The child itself income was low, but then the intended immigrant, remember the person who's trying to get status is still working under that work permit. So as an intended immigrant, then we had to show that we can also file I-864A, okay? The sponsor and the intended immigrant together, then we show to the judge that the income requirement for poverty guideline has been met. We cited some rules, and finally, the judge has decided, that's August 23rd, the judge has terminated removal proceedings. This is the timeline, right? We started July 19. It's just that on August, okay, of 2022, the judge has finally terminated removal proceedings. Now we can go back to USCIS and adjust status with USCIS. Family-based petitions taking about 18 months now. Well, will they go with that priority date for I-130 petition? We hope so that she doesn't take too much time for the green card to arrive. Okay, this is it. It's a good case. The facts were good in our favor, but still we had to have a strategy on how to get her outside of the court system. Because remember, adjusting status in court, the standard is sometimes higher, and sometimes people don't make it, okay? And remember, we tried prosecutorial discretion. It just didn't work. At least twice, it didn't work. So we had to come up with proof enough to convince the judge to terminate proceedings based on the fact that no other inadmissibility issues are in place, and income requirement is going to be met with the sponsor and the intended immigrant. Okay? Bijoux, Ngwanda here, immigration lawyer in the DC metropolitan area. If you need a consultation, please call 202-751-2180. Email bijou.ngwandaesq@gmail.com. Consultation fees apply. You can also schedule your consultation by just clicking the link below in the description box. Until next time, bye-bye.